Hello, my true crime lovelies. How are you? I hope you are well. I hope you are as lovely in life as you are in my mind. And if not, I hope you're on your way. I hope you're on your way. I know every day is not a good day. And so if it's not, I hope it gets better for you. All right. So we are one business week away from Sarah's family court hearing trial. Today's the 15th. It's Friday the 15th when I'm recording this. And today is the due date for the exhibit list. So a week from next Monday is her hearing trial. Does that make sense? So I just want to ground us because Brian has submitted his exhibit list. Sarah has not yet submitted hers. I say not yet because she has until the end of the day today on the 15th to record it or to have it recorded in the docket. You know what I mean? So she has time. But we're going to go over what the court outlined as its expectation. Just a refresher. I did a full video on it. We're just going to hit some bullet points so that this makes more sense, especially if it's your first time getting an update on what to expect at the trial. And then we'll go over what his exhibits are. But first, I'm going to thank the members. I'm going to run the intro and thank you for being here. If you like the video, consider giving it a thumbs up. And if you haven't subscribed yet, we'd love to have you. We're a fun bunch over here. All right. I'll see you on the other side. All right, here we go. So just as context, they have a new judge as of January 2025. It's Judge Jackson. Prior to that, it was Judge Michael Dean who was presiding over the case. They've had several hearings with her, pretrial hearings, and like where are you and what's going on with the readiness hearings. So they're familiar with her. However, the trial will be like the real deal, and I'm excited for it. But let's look at what Judge Jackson sent out as far as her expectations. And I love this. I love when people outline, here's what I expect, here's what you can expect. So no additional hearings shall be secured pending the final trial. So the one they had on, I believe it was May 29th was their final hearing. Any outstanding motions, they have to be filed 10 days prior. So that's 10 days prior to the trial. So we're less than 10 days out. Nobody has filed this cross notice for the same day time as the trial. So Sarah should have, if her intent was to have her motion for contempt heard, she should have filed a cross notice so that it could be heard on the same day time as the trial. Otherwise, it shall be deemed waived and denied. So she's not going to be able to refile it later. I suspect it's going to be moot anyway because the judge is going to once and for all say, you know, he doesn't have to pay at least from 2022 forward until the alimony expired, which would have been April of this year. That's what I'm speculating. The 2020 to 2022 is in question because he had not yet filed the motion. And we looked at that case law in the last video. I'll link it in the iCards. Okay, that's the Rosenblum v. Rosenblum. And then there's an offshoot of that one. But it is either way, I think her motion for contempt will be moot. Okay, all exhibits must be marked prior to the start of trial, which will begin exactly at the time listed. So all witness lists and exhibits for trial have been exchanged or will be exchanged by this date, August 15th, 2025. So that is today, y'all. So Brian got his in on the 14th. We'll see if Sarah gets hers in. So any changes to the joint pretrial memorandum or joint equitable distribution spreadsheet, or parenting plan should be provided to the court no less than 3 business days prior to trial. So they have until, I guess, is Wednesday 3 business days? I guess it'd have to be Tuesday night, right? So, because then you'd have Wednesday, Thursday, Friday would be the 3 business days. We know they didn't do a joint trial pretrial memorandum. Sarah didn't technically file all of these. She sent like that 133-page rant that I think she's hoping will qualify, but I expect she'll get a dressing down from the judge for not following directions. What grade is it? I feel like it's like we're very young. It's like maybe second or third grade where the teachers give you this test to see if you can follow directions. Now, I know Sarah says she was a straight A student. We don't know all the details of that. Like, did she bully the teachers until they gave her all straight A's? Was she a straight A student in kindergarten? Like, she doesn't mention that she graduated like summa cum laude or magna cum. No, what's higher? I think summa's. What's the very top of it, whatever that is. She's not mentioned it. She just goes on about being a straight A student as a 42-year-old woman, referencing her high school education. I don't think she passed, is my point, of the following directions, because she struggles with that. And I don't know why. Like, and also like her helpers, her flying monkeys, seem to struggle with that, or they're afraid to like redirect her to like, this is what the judge asked for. This is, we should strive to like give the judge what she asked for. No, they're not worried about it. Okay, so, and then we know the trial will begin with questions from everything that's been submitted, and there's no need to send in a court order. The judge will do that. So now that we have that as context, let's head on over to what Brian has submitted for his, I'm going to hide the toolbar, for his exhibit list for trial on August 25th. There's 2 if you look at the docket. I'm just doing the second one. It was amended to correct the certificate of service. Otherwise, they say the same thing here. So Exhibit A, pretrial memo filed 5/08/25. So that was the very first thing that we looked at of what Brian had submitted. Actually, no, we looked at his financial affidavit first. But anyway, so that was the one where the judge kind of like smacked him on the wrist, he and his counsel, Brian, because they were supposed to do it with Sarah, and they just put, yeah, because she's in prison, we're not doing that. So here's ours. The only like admonishment was they should have sought leave from the court first before doing that, but she wasn't like mad that they hadn't done it. And Sarah didn't submit that until, oh God, what are we? I think July. She submitted that in July, and it was not in the right form. Okay, then child support guidelines worksheet that was submitted. And you'll notice it says Bates numbers 1 through 8 for Exhibit A, and then each one has that. I didn't know what that meant, so I looked it up. I'll share with you really quickly in case you too don't know what this means. What is Bates numbering, also known as Bates stamping, is a method of sequentially numbering pages. It's especially useful for situations involving a large number of documents, such as indexing medical records, business receipts, or in legal preparation. By giving each page a unique reference number, the Bates numbering system makes it easy to reference and retrieve information from a specific page. The history, although consecutive numbering systems have been used previously, the Bates system gained popularity in the late 19th century, so the 1800s, following the invention of the Bates automatic numbering machine, or the Bates stamper, named after its inventor, Edward Granville Bates. The stamp featured a rotating wheel of numbers, which moved incrementally every time a page was stamped, which is kind of cool. So despite its ostensibly archaic roots, the Bates numbering system is still widely used in the field of law, making it easy for documents to be referenced in court. However, rather than using a physical stamp, most of the numbering is now done digitally on PDFs. So the numbers can be added to files manually using software such as document management platform, or they can be added by an external document management supplier. The benefit of this digitization means that attorneys and other professionals can search for a document by its reference number, meaning they can find it in seconds rather than minutes. So that will be helpful during trial and after. So that's what the Bates numbering is. So the Child Support Guidelines worksheet filed 5/9/2025, Bates 9 through 10, where basically Brian was like, if anybody owes anybody child support, she owes me child support because I've been a single parent since February 25th of 2020. Case law, Exhibit C. So Sarah did not submit any case law document. Well, she hasn't submitted any exhibits. And even like the case law that she cited in that random rant of 33 pages, she didn't like extrapolate what part she was citing, like what her specific citation was. So it's going to be a hot mess trial. But anyway, so 11 through 28. And it'll be things like Rosenblum v. Rosenblum and the other things he's relying on as far as why he filed for the change, why he wants full custody, etc. Exhibit D, petitioner updated the financial affidavit filed on 4/25, and that's Bates 29 through 40. Exhibit E, a respondent financial affidavit was filed 5/30, Bates 41 through 48, and that's the handwritten one. She never submitted the typed out one that the judge gave her an extension to do, and would accept the handwritten one as like an interim document. Who knows what happened there. Billing records, Bates 49 through 79. So I don't know what these billing records are for. What do you guys think? I'm thinking it's either like storage for all of her heirlooms, or what else? What other billing records? What else would he have paid for her? Hopefully he wasn't still paying her rent, because she didn't get evicted for non-payment of rent. She got evicted for being a criminal or being accused of criminal acts, right? Yeah, so I'm curious as to what the billing rates are. One of you guys asked, like, because we were from the video where the 33-page rant where Sarah was like, I was coordinating with my brother and Brian wasn't cooperating, former husband wasn't cooperating. And you asked if in any of the text messages, if she ever asked her brother Philip about going to get the car, going to get the heirlooms. And the answer is no, she did not. I think she just made it all up. But, you know, she can attest to whatever, unless they talked about it on the phone. Like, to be fair, maybe she talked to her brother and made arrangements to go and get her stuff on the phone. Anyway, it's not something that Judge Jackson has jurisdiction over. There's no contract. It's just like, it's foolishness, but you know, something to laugh at. We can count on Sarah's weirdness to keep us entertained. So Exhibit G, parenting plan for trial, filed 7/17, Bates 80 through 82. That's the one that got Sarah really upset. Like, she had that emotional response in the 33-page. Like, he's doing that and he hasn't consulted with me and I haven't signed it. It's like, no, ma'am, it's a proposal for trial, for discussion of what he would like to as the outcome. And then Exhibit H, respondent's order on temporary relocation. Ooh, excuse me. Bless me. So I'm not sure why there's not a filing for that to be marked as permanent, right? It was temporary pending the outcome of her trial. And I realized in the other video I kept saying until she was found guilty. It wasn't, obviously, they don't know if she was going to be found. We knew. But it was until the outcome of her trial, is what I should have said. But now that we know she's been convicted, I think the temporary relocation should be changed to permanent. So maybe that's why he's putting that here. Josh Martell's putting that here because he's going to argue orally about it. I'm not sure, because there wasn't a separate motion, but I guess it was implied that once the trial was settled, that there would be a ruling of whether that would be rescinded. Like if Sarah were found innocent, and she got to go home, or not guilty, they don't find you innocent, not guilty, and she got to go home, then they would revisit it and possibly rescind the relocation. I'm not sure. But anyway, he's got that in there. So yeah, go Brian. We'll see if I don't know how it's the last day. So even if the flying monkeys see this video and our like light bulb goes off of, oh, she was supposed to file something, it'll be too late because today is the date that it is due. I'm sure she'll be blaming someone because even they filed this yesterday. What time was this filing? 10:59. So, but even if they saw it yesterday, Sarah's not going to get it. I don't even know if she'll get it before the trial because sometimes it seems like it takes 10 or more days for her to get documents. Yeah. And this is only the notice, so they don't attach all the exhibits, although they submit it. I'm not sure. I mean, I guess they would have to send it all to her. They would send the actual exhibits to the court, send them to her. But again, she's not going to get them until afterwards. Most of them she should have, except for this billing records, because everything else was filed throughout this process this year with the court, except for that billing. So we'll see. But yeah, Brian is ready. He's rocking and rolling. I'm excited for him. I'm rooting for him. As far as I know, I will be at the trial. Anything could happen. I'm 28 weeks pregnant. I think I'm 28. Today I might be 29. I might be confused though. It could be, for sure I'm at least 28. We'll say that. So anything could happen, but knock on wood, I'll be there and get to see it in person. Sarah won't be there in person. She's going to be telephonic, so we won't even see her face. And then I didn't see anything where the petitioner, like Brian or his attorney, filed to be there telephonically, but I don't know. It might be automatic because, since Sarah is, we'll see. So many questions I have, but we're getting close to the end. And then the judge will send out the orders afterward. And she said in that note, if you don't have it within 14 days, contact the judicial assistant, judicial clerk. And so by mid-September, we should know, like, is Brian fully free? What does visitation look like? I did do a little bit of research on visitation. I'll do that in a separate video because it's a little nuanced, and YouTube and thumbnails, it's easier to have like one subject in there. So, all right, I appreciate you guys. What do you guys think? Are you excited for the trial? Do you think he's going to get full visitation, no alimony, no child support? I'm hoping that's what he gets. I'm worried about those 2 years, but that would be what, that'd be $24,000. I just don't see the judge doing it, even though, because there's a letter of the law and the spirit of the law. I think she's going to go with the spirit. I hope she is. Why, as a single parent, should he have to pay this incarcerated wench $24,000? Let me know your thoughts. I'll talk to you guys in the comments down below. Toodles.